Hi, my name is Carl Krueger. I'm one of the staff attorneys at the Dorcas International Institute in Providence, and I'm here to give another one of our periodic updates on new trends in the world of immigration law. Today, I'm going to be talking about the public charge ground of inadmissibility. This is a relatively new change that went into effect with USCIS applications about 2 weeks ago. The grounds of inadmissibility that I'm going to be talking about today have to do with individuals who are in the United States applying for permanent residence here in the U.S., as opposed to folks who are doing consular processing, which means applying for their permanent residence or their immigrant visas at a U.S. embassy. We'll save that topic for another day. Grounds of inadmissibility are the reasons that the government can use to deny someone a green card. There are about 30 different grounds of inadmissibility in the current immigration law. Criminal grounds, health-related grounds, political grounds, bad immigration history grounds are some of the more common ones. But the public charge ground of inadmissibility also is applicable to anyone applying for permanent residence in the United States unless they're specifically exempted from that requirement. Basically, the public charge ground holds that if an individual is likely to become a public charge, he cannot get a green card. So it's a prospective test, generally, meaning that immigration is looking at your situation now, trying to predict what is likely to happen with you in the future. That is, that you're not likely to become a public charge. Now, there are certain grounds or certain categories of people who are applying for green cards who aren't subject to this public charge ground. Mostly, these are humanitarian-based applications. For example, refugees, asylees, Cubans who are adjusting under the Cuban Adjustment Act, special immigrant juveniles, victims of crimes, and also, especially important to us here in Rhode Island, Liberians who are applying under that new LRIF law. These categories of applicants for green cards are not subject to the public charge ground. It's just not an issue for them. Now, what the public charge ground of inadmissibility has meant up until now is that if an individual who's applying for a green card has been in the United States and has been dependent on cash assistance, primarily food stamps or SSI, in order to support himself or herself, or if an individual has been institutionalized for a long period of time, say at a nursing home, at government expense. In those two scenarios, yes, the government has applied this public charge ground of inadmissibility and has disqualified individuals from getting permanent residence on that basis. But those are rare cases. Specifically, the dependence on the cash assistance, these are benefits that generally are not available to someone who doesn't have a legal status. And we're talking, of course, about someone who's in the process of applying for that permanent residence. So they wouldn't generally have been eligible for food stamps or SSI. So it was a fairly uncommon reason for immigration to be denying someone's application for permanent residence, at least up until these changes went into effect 2 weeks ago. Additionally, for the last 20 years, in any kind of a family-based petition, and most of the people who get green cards are doing it through a family-based petition, in those scenarios, the petitioner, the U.S. citizen or permanent resident who's filing the petition for the relative to give the relative the green card, that petitioner has been required to sign an affidavit of support. And this affidavit is a contract with the government where the petitioner is showing that he or she has the resources to support the new immigrant at least 125% of the poverty level for a family of their size. And it's an enforceable contract, which means that if the new immigrant were to receive certain types of benefits, the government could go after the petitioner and require the petitioner to reimburse the government for the costs that the new immigrant has incurred. Again, a pretty uncommon scenario, but that is how it has been for the last 20 or so years. And the nice part about the Affidavit of Support was that it really removed a lot of the arbitrariness of the process. Basically, if you had a petitioner who was making at least 125% of the poverty level for a family of the size of that petitioner, a dollar over the limit was good to go, and if you were under that, you knew you had an issue and you probably needed a co-sponsor. But again, it really removed a lot of the arbitrariness. This, unfortunately, is what this new rule that went into effect two weeks ago is going to bring back into the system. Now, there is a strict definition of who a public charge is. And a public charge, by definition now, is a non-citizen who has received over 12 months of public benefits within the last 36 months. Again, because people who don't have green cards are generally speaking not eligible for these benefits, there probably are not going to be very many people who are going to be brought within the language of that definition. But the new rules also apply a prospective test, which is to say immigration now is going to be attempting to forecast what is likely to happen in the future. And they're going to use a totality of the circumstances test. So what this means is they're going to be looking at a number of factors, focusing on the alien, as opposed to with the affidavit of support that I mentioned a minute ago, looking at the petitioner's resources. Now they're really focusing on the alien and whether the alien is likely to be able to support himself or herself. So among the factors that they're going to be looking at are age, health, the size of the family, the size of the household, the alien's assets, resources, financial status, education, and skills. They're looking at how long the alien is going to be in the United States, because this rule applies also to people who are coming in on certain types of non-immigrant visas. Non-immigrant visas being permissions to be in the United States for a specific period of time to do a specific thing, after which the alien is going to be leaving. Because that person isn't going to be here for a long time, the test is a little bit less rigorous for that individual. But someone applying for a green card, of course, is intending to be here permanently, and so the test is going to be strictly applied. The affidavit of support is still going to play a part. It's still going to be required in all family-based petitions, and again, there are exceptions to all these rules, in most family-based petitions. There's going to be an affidavit of support, but it's going to be given diminished weight. Again, the Immigration Service is going to be focusing much more on things like the age of the applicant. And they have said explicitly, if you're between the age of 18 and 65, that's a positive. If you're under 18 or you're over 65, that's going to be deemed something of a negative factor. The health of the individual. Obviously, if an individual has some pre-existing medical condition that the Immigration Service forecasts is going to require a lot of money to take care of, that's going to be deemed a negative factor. The size of the family. Small family is good. A bigger family will need more resources, and therefore that's going to be deemed a negative factor. They're going to be looking at the assets, resources, and financial status of the applicant. And a big factor in all of this is the notion of health insurance. If an individual who's applying for a green card can get private health insurance, because Obamacare or any other government subsidized insurance is not going to be viewed as a positive factor. But if you have private health insurance, that is viewed as a tremendous positive factor. And education and skills. Do you speak English? Have you gone to post-secondary education? And can you prove it? So these are the factors that immigration is going to be taking into account. Again, looking at the totality of all these circumstances, weighing out the positives and the negatives. The big drawback to this, most people are going to see immediately, is the arbitrariness that this is going to bring into the process. Unlike the good old days where we had an affidavit of support, and if you were $1 over the limit, you were good to go. Here now, you're going to have two adjudicators looking at the same set of facts, and one is going to find that the positive outweighs the negative, and the other is going to find in the opposite way. Two exact same cases that are going to be decided differently. That's the very definition of arbitrariness. The explicitly heavy negative factors that are identified. If an alien is able to work, which is to say he has work authorization, but he's not working, that's a heavy negative factor. If the alien has received public benefits, and again, public benefits include things like food stamps, SSI, Section 8 housing, that's a negative. Again, not many people are going to get caught up in that, because generally if you don't have a green card, you're not eligible to get access to those benefits. And if you're in a household where some members have gotten access to benefits because they're eligible to do so, that is not going to be counted against you. And the third heavily negative factor is going to be a serious medical condition with no insurance. Now, the explicit heavy positive factors, if the alien or the alien's household is at an income of 250% of the federal poverty level. So it's basically double what is now required to be shown on the affidavit of support. If you're at a level of 250% of the federal poverty level, then that is a very, very positive factor. And the other, I mentioned before, private health insurance. Not Obamacare, not anything government subsidized, but if you have private health insurance, that is going to be an explicitly heavy positive factor. One other thing that this new regulation has brought into play is a new form, an 18-page form called an I94 This form is required to be submitted with any adjustment of status application, any application for permanent residence that was postmarked after February 24. This I-944, if the public charge ground of inadmissibility applies, which is to say if you're not in one of those categories where you're exempt from that, then you have to submit an I-944. This I-944 is asking very, very detailed information, not just about the alien applicant, but about the members of the household, assets, liabilities. Aliens are now going to be required to do a credit check on themselves and submit the results of the credit check. And if they have post-secondary education, they're going to have to get that material evaluated, transcripts evaluated if you went to, for example, a university in a foreign country, which can impose a pretty serious financial burden on some people. So that is, in a nutshell, the public charge ground of inadmissibility. Again, this applies to all applications that are being filed now. Anything filed prior to February 24, 2 weeks ago, is not going to be subject to this new rule, but any of the newer cases going forward are going to be. This is a very broad overview. This should not be taken at face value as a substitute for legal advice. If you have questions about this, please come to Dorcas and take advantage of our free consultations. Every morning, Monday through Friday, we have caseworkers available. You can walk in without an appointment and get a free consultation. We'll try to answer your questions and walk you through this. Thank you for watching.